Well, hello there, everybody. All right, good to be here. What it means to be an independent executor. I have had a lot of conversations over the years where people have asked me, what does it mean to be an independent executor? What is an independent executor? How do I become an independent executor? What powers do I have as an independent executor? What powers does my brother have? What powers does my sister have as an independent executor? So we're going to lay it all out here for you today. Quick introduction. My name is Paul Rabalais. I'm an estate planning attorney. As far as my education goes, after my undergraduate degree in finance and then my law degree, after that, I earned a master's degree in tax law from Boston University's law school. Came back to my hometown in Baton Rouge, Louisiana, started practicing law as an estate planning attorney in 1991. And several years ago, after establishing this YouTube channel and having it kind of take off, we arranged our estate planning business to be able to help people around the country by building and utilizing our co-counsel network of attorneys in other states as well. So let's jump right into it. Why discuss the concept of an independent executor? Well, and I have to give you my little disclaimer here. Every state has their own set of probate rules. Probate is that process of when somebody dies with assets in their name, there's a court and attorney involved process where judges get involved. And for whatever reason, many, many years ago, it was determined that our courts will oversee the distribution of someone's estate to their heirs. And so that most states call that process probate. The executor is the person in charge that's been designated to kind of make sure the probate runs how it's supposed to run. But I'm going to focus because I have to focus on, if I'm going to get kind of nitpicky about this, I'm going to focus on the independent executor rules as it relates to Louisiana probates. But I've done enough work around the country to know that they're similar in other states. But I've been the attorney involved in thousands of probates. And so I'm going to focus on our Louisiana probate rules. Now, it's important to discuss the concept of an independent executor because having someone as an independent executor makes the probate easier because the actions of that executor can be independent of judicial overview. More on that later when I give you an example. But you need to know about it when you're getting your affairs in order, because there's designations in your estate planning documents, in your last will and testament, that have to be there to enable that executor to make it easier for that executor to do what they need to do when you pass away. All right. So first, let me talk about how someone becomes an independent executor, and then I'm going to give you an example which gives you, the idea of what an independent executor is. And again, we're focusing on what is an independent executor versus what is an executor without that independent preface. By the way, hello, Larry. Always great to see Larry. Sheila, hey, great from Louisiana. Rosemary, great from New York. Good to see everybody. Okay, so how someone becomes an independent executor, even though I really haven't yet described what that means, is many independent executors of estates become independent because the person whose estate they're administering, the person who died, had a will, and in that will, it may have said something like, I'm being real simple here, but I name Ed as my executor. And maybe in the will, it also said, I authorize Ed to serve as an independent executor, or my executor may act as an independent executor. So that phrase in the will allows the executor to be an independent executor. And again, being an independent executor is typically better than being an executor because it's a streamlined process, as I'll discuss here in a minute. However, sometimes wills say, I name Ed as my executor, and it doesn't say anything about Ed having the ability to be an independent executor. Either the will was written a long time ago, or maybe it just, it didn't get in the will for whatever reason. So if that's the case, at least under our Louisiana probate rules, if a will names someone as an executor and it doesn't expressly authorize that person to be an independent executor, then all of the heirs can sign an agreement allowing Ed to be what's called an independent executor. Okay, enough of that legal mumbo jumbo, the gobbledygook. Let me give you a just plain old example to give you an idea of what I'm talking about. So let's say mom died. Let's say dad wasn't in the picture. Dad either died many years ago or maybe mom and dad were divorced. And so you just got mom. So mom passes away and mom left a last will and testament. And in that will, one of the many provisions, it designated Ed as either the independent executor or it named Ed as the executor and said that the executor may act as an independent executor, but it had that language that's required to enable the executor to be an independent executor. And of course, there's many other provisions in the will, but let's say mom kept it relatively simple and she left her estate to her 3 children equally. Her children were adults, all, responsible. Maybe they get along, maybe they don't. Let's say they do. But because if they don't, it creates another set of issues. But after mom dies, the will gets produced and Ed will likely hire a lawyer and Ed's lawyer will prepare all these petitions and all these court documents asking a judge to declare that mom's will is valid and asking a judge to confirm that Ed is the independent executor. The petitions and the will and all the paperwork gets filed at the courthouse. Judge's office reviews it. Judge signs the order. Yes, mom's will is valid. And I'm confirming that Ed is the independent executor. All right, so what happens next? Well, what happens next is Ed will go open an estate account at a bank. Maybe some of mom's accounts are frozen. And so Ed can go, with the court order confirming that Ed is the independent executor. Let's talk about that for a minute, because a judge will sign a court order ordering that Ed is the independent executor. That court order makes its way to the clerk of court's office, and then the clerk of court's office issues multiple certified copies of what I'm going to call in this case letters of independent executorship. Now, if you've ever had a family member die and you've gone to their financial institution, and whether it was a bank, a credit union, a brokerage firm, or whatever, maybe the financial institution or a representative of the financial institution said, sorry, we can't do anything for you. We need letters testamentary. They always use the words, we need letters testamentary. So back in the old days, before there was such a thing as an independent executor, that was the document that everybody got, and that was the document that everybody produced to the financial institution. Letters testamentary. Now, I will tell you, lay people think that's some kind of letter from the lawyer to the financial institution. They just need a letter because the financial institution said they need letters testamentary. In my mind, that's a letter. Hey, write a letter. But it's nothing like that. I wish they'd come up with a different name for it because it has nothing to do with somebody writing a letter. But all the financial institutions, when somebody dies and a family goes to the financial institution, oftentimes they'll say, sorry, we can't do anything without letters testamentary. Well, in this world of independent executors, the document that the court produces isn't called letters testamentary. It's called letters of independent executorship. At least that's the case in our world here in Louisiana, but I'm sure it's the case in many other places as well. So the executor gets certified copies of these letters of independent executorship, goes to a bank, opens an estate account, which will be a temporary account. Could be a temporary account, could mean it's open for 3 months, or it could mean it's open for 3 years. But that's the money that the estate funds are going to go into until the estate is finalized, when the estate account is closed and the funds are used to disperse to the heirs and pay other debts and that kind of thing. All right, so let's go back to it. Ed is now the independent executor. He's gone and opened an estate account. Again, he can't do that until a judge signs a court order confirming that Ed's the independent executor. Okay, now here's the deal. if Ed was just an executor and was not an independent executor, Ed would have to go through a lot more red tape to get stuff done as the executor. For example, if when mom died, she had some debts that needed to be paid, maybe it was debts related to her house, maybe her mortgage, maybe her car loan, maybe her credit card bill, maybe her taxes need to be filed. Well, if Ed is only an executor and not an independent executor, Ed's got to go get a judge to approve all of those actions, like paying mom's debts after mom dies. And so it's a lot more red tape. It takes a lot more time, a lot more hassle. However, if Ed is the independent executor, he can take those actions, as we say, independent of court approval. So we're not eliminating the probate here. Still got to go through the court to have a judge declare that mom's will is valid. Still got to get a judge to confirm that Ed is the independent executor instead of just the executor. However, some of these day-to-day actions that Ed may need to take, he doesn't have to go get a judge to give him permission to do it. If he's the independent executor, he can take some of those actions independent of court approval. Doesn't have to get a judge to say, okay, you can pay mom's mortgage and have a judge sign an order and all of that. So Ed he'll pay mom's debts as the independent executor. He'll pay for her funeral, pay for her credit card bills, pay her house note, pay her taxes. Ed may even sell mom's home, excuse me, if that's appropriate as the independent executor. If he's not the independent executor and he's just the executor, well, a lot more difficult for Ed to sell mom's home. He's got to get a judge to approve it, and to get a judge to approve the sale of mom's real estate, he has to do some advertising in the newspaper, let all these potential creditors know that he's selling mom's house. And those advertisements have to be weeks apart. It's a several month process for an executor in Louisiana to sell the real estate of a deceased person if they're only an executor and not an independent executor. If he's the independent executor, boom, he puts the house up for sale and sells it. Proceeds go into the estate account. He's rocking and rolling. Doesn't have to get the judge to specifically approve the sale of mom's home. Ed can sell mom's car as the independent executor. Again, if he's not the independent executor, got to get a judge to approve it. So you're probably starting to see here that being an independent executor is a lot easier. I don't even like to handle a probate when someone is not an independent executor. In fact, if someone's not an independent executor, it probably means a couple of things. It means, one, the person who wrote the will didn't expressly authorize an independent executor. And maybe, rarely does someone intentionally not specify that their executor can be an independent executor. Sometimes it just happens because maybe the will is old before the law took effect, or it's just a poorly written will. And then if it wasn't authorized in the will, then the executor is not, if the executor is only an executor, it's because there's one or more heirs who refuse to sign an agreement authorizing the executor to be an independent executor. And that's not a good sign. If someone's refusing to permit the executor to be independent, it's probably because they don't trust him. They don't want to sign anything. It's adversarial, and there's going to be some kind of contest. So anyway, we always want the executor to be independent. It just means they can take certain actions within the probate independent of court approval. And if they're just an executor, they got to go through more red tape to get things done. All right, few other issues that are involved with the old independent executor. Looks like we have, why don't we get this? I'm going to, give me a second here. I need to hide the user on the channel. Okay, so there we go. All right, let's go back to it. Let me get myself back up. I've been getting some weird chat stuff. So every time I see one, I just hide the user from the channel. All right. Some other issues related to an independent executor. Some people mistakenly believe that if you write a will And if you state that your executor can be an independent executor, then there's no need to have a probate. And that's false. You still have to have the probate. You still have to open a court proceeding. You still have to have a judge sign up an order ordering that the will is valid. You still have to have a judge order or confirm that the executor is the executor, and courthouse issues lots of documentation. Still have to get final court orders ordering that assets be distributed to the heirs. It's just some of those day-to-day activities that an executor would normally have to get a judge to approve. The judge doesn't have to approve those day-to-day activities if the executor is an independent executor. Here's another issue related to independent executor. Let's say a person died without a will. Okay, if a person dies without a will, there's just not going to be an executor. There may be an administrator, which is a similar role, or some states call it a personal representative, but there's not going to be an executor if there's no will. So what happens is typically you typically need somebody to collect the funds, open the estate account, do what needs to be done, pay the debts, disperse the money to the heirs. So if someone dies without a will and they have assets in their name and there needs to be a probate, and then since the person died without a will, there needs to be an administrator, because if you have a will, the will names an executor. If there's no will, the court appoints an administrator. And again, if a person died without a will and there's going to be an administrator, we want that administrator to be an independent administrator. How does an administrator become an independent administrator? Well, all of the heirs who are going to inherit from that person who died without a will, all of those heirs must sign a special agreement acknowledging and agreeing that the person who stepped up and said, I'll do it. All the heirs must sign an agreement authorizing that person to be an independent administrator. So you have independent executor when there's a will, and hopefully your probate has an independent administrator when there's no will. All right, a couple of other things, at least here in Louisiana, sometimes these probates can be handled without what I call an administration, without an executor or an administrator appointed or confirmed. Let's say mom died. Maybe she had a will and left everything to her 3 children, left her estate. Maybe she didn't have a will, and as a result of the state law, everything goes to her 3 children. And she died, and that's the only asset she has in her name, is that one piece of property. There's nothing else. There's no debts. There's no frozen bank accounts. Maybe mom had an IRA that was where she designated beneficiaries. No problem. That's a non-probate asset. Maybe she had a Roth IRA. Maybe she even had some life insurance. She designated beneficiaries. Those are outside of the probate stuff. So the only probate asset is her home. And the 3 children decide, you know what, let's just keep the home. Maybe we'll rent it. Maybe we'll just keep it in case somebody wants to, come into town and stay there, whatever. So sometimes, at least here in Louisiana, we handle these probates without an administration, without an administrator if mom didn't have a will, or an executor if mom did have a will, without needing an administration. The heirs just, of course, through lawyers, they prepare court paperwork. That court paperwork is basically a petition telling a judge, hey, here's the 3 heirs. There's only one asset. There's no need for an administration. We just need this one piece of property put in the 3 children's names. And then a judge signs what we call in Louisiana a judgment of possession, ordering that the asset be transferred to the 3 children. That judgment gets recorded in the real estate records of the parish. Here in Louisiana, we have parishes, not counties. And then that makes the 3 children the co-owners of mom's home. So sometimes you can get a probate done without there ever being an executor or administrator. Let me give you another example I was dealing with in the last few days, where someone in Louisiana, because Louisiana is one of those 25 states or so that permits handwritten wills, we call them holographic wills. And as long as you follow the rules, the will is valid. And this person did follow the rules. It was entirely in their handwriting. It was dated. It was signed at the end. And they made no mention of an executor. So since they made no mention of an executor, she didn't appoint anyone as the executor. She surely didn't say that her executor may act as an independent executor. Now you got to go through the courts and get what's called, because she didn't even name an executor, we've got to get what's called a dative executor appointed. And again, if all of the heirs agree, then that dative or court appointed executor, because it wasn't mentioned in the will, can be an independent executor, and again, get things done without as much judicial supervision as there would be if that person were just an executor. So sometimes people write wills, and for whatever reason, it was oligraphic or it was just poorly written. They don't even address the issue of executor. Then there's some rules for how that gets done. All right. So that being said, that's going to wrap us up for today. If you have some topics that you'd like to see me address, throw them in the chat, because I'm fixing to ramp this thing up. So many people over the last couple of years have told me how much they've learned and gotten out of these YouTube videos. And I have a lot of experience, a lot of things I can share, try to explain complicated concepts in relatively easy to understand terms. So glad to have you here, Larry, Sheila, Rose, Brown Eye Girl, fantastic, and Shelly from Indiana. Good to see you all. You'll have a great evening. Take care.